Hello everyone, welcome to Court with Krissy. Here are 4 court shorts you probably didn't catch, and this time they are all updates. Kicking it off with Mr. Brian, who is back requesting another continuance. Some things never change. If you missed any of the previous appearances, they are all linked in the description. I hope you like it. Court with Krissy is now in session.
Mr. Brian's here. Mr. Brian, how you doing on getting a lawyer? Mr. Brian?
I haven't been able to get a lawyer.
Well, when are you going to get a lawyer?
And Your Honor, if I recall, I think a 1077 was fine.
How are we doing? Did the hospital contact you or did you contact them?
I only want to say one thing. I'm asking for continuance, and I have a flight going to Pennsylvania the last week of August. I'm asking for continuance, pleading not guilty.
So what I'm hearing is the hospital contacted you and
You
you.
contacted me.
Do you know anything about that, Mr. Paganelli?
One moment, Your Honor.
That's okay. Well, technically, you're not entitled to a continuance because we're into a 1077 situation.
I'm asking for a continuance because I already arranged a trip for Labor Day to Pennsylvania.
1077s have a very long wait list. And typically, they're not going to reach out to counsel. Now, they may be confused because there's no defense counsel listed.
Right.
But usually most communications from the hospital go to all parties listed on 1077. So presumably there's a higher balance on there. But his office could reach out and get an idea of time frame. But last time I did it out of custody 1077, it was 12 months.
And what I have, Your Honor, is from the RSP from the out of custody forensic navigator.
Right.
Which
I'm looking at
indicated
that
an
too.
inability to meet with Mr. Brian.
Let's see.
And you have navigators who are new, they can help facilitate the process. They might also come up with alternatives.
The client reported he retained counsel, yet counsel did not confirm being retained and respond to forensic navigator's request for an interview. Client remains out of custody. Once this client is scheduled to receive their forensic evaluation, the case can be reopened by either contacting forensic navigator directly or filing an MP 203 order. So, Mr. Paganelli, and since Mr. Kressel is standing there, so it looks like the hospital has been unable to contact Mr. Brian for whatever reason. Is that how you're reading that, Mr. Paganelli, or not?
Your Honor, the Andrea Carey Grant, the forensic navigator, is one of the aspects of the 1077, but I do not believe it's the professional evaluator. Like I said, I believe this is for out of custody review of forensic diversion. So I do not believe that I cannot confirm that the hospital has attempted to contact Mr. Brian. I don't have anything, but my understanding is they generally work through an attorney. And if he doesn't have one, I don't know if they are working a little bit differently in that regards. This is the first time I've had a 1077 without an attorney.
Your Honor, just
Yeah.
the forensic navigator, they receive a copy of the 1077.
Right.
They don't do the evaluations.
Okay.
They write up a report if a person is found incompetent.
Right.
If they are willing to do restoration out of custody and basically potentially a restoration process.
Well, what I need to know, so you think somebody
ends up as a diversionary type program, whereas the hospital will reach out directly.
Right.
Since there wasn't defense counsel on there, I would suggest the state reach out to the hospital to see what the time frame is, because in the past it was rather lengthy. However, since they do a lot of this stuff by Zoom now, they may be able to, but generally speaking, there's a long wait list.
Well, we need the hospital to contact Mr. Brian. I wonder
Can I
how
say something? I don't have a phone. I want to say that. I don't have a cell phone.
All right. So
if my wife, listen, if they had my phone number, my wife would have gotten that message.
So at some point, you're going to have to talk to them. Do you understand that?
Whatever you say, I'm listening.
Okay, good. So at some point, we want the hospital to contact Mr. Bryan, the phone number we have, and or a letter. I'm assuming they send those out. I've seen those before.
They will send an email, usually, again, when council's involved, they will propose a time.
Right,
If it's out of custody, it's usually a couple of weeks ahead of time.
right.
They'll usually give a variety, like 3 or 4 different time available.
Right.
They will suggest, okay, it has to be in a professional environment.
Well, based on your
office.
recent experience, how long is it taking before they finally get around to that out of custody?
Out of custody once in the past for about 12 months. Now, whether or not they sped that up, given all the litigation going on on the federal side, that I don't know. The in custodies are usually done, and we have a bunch of those. They're being actually done today or tomorrow.
Right.
Those are typically done within about 2 weeks, but the out of custody, it takes some time, but even in best case scenario, you're probably still looking at a few months.
Well, so what we want to do, Mr. Paganelli, is another review date to figure out where we are on this. And Mr. Bryan, I'll say the same thing I've said to you in the past. You don't necessarily need to drive out here. You could appear by Zoom.
I'm not gonna use Zoom. At this point, I've been here so many times, I'm gonna come in here. It's easier for me just to come here.
Right. So when is
And I
this?
haven't used Zoom, I don't have the right kind of computer and stuff.
I'll note, Your Honor, that will further delay the process.
Which will delay the process.
Zoom, as the alternative would then be in person.
Gotcha. No, I'm just saying that somehow we have to review whether or not the hospital is taking steps to contact Mr. Bryan, and I don't know how to do that from here.
I will reach out, Your Honor, when I get back to the office. Obviously, I'm not going to be doing that in the courtroom.
I know. And what is your time that you leave in town?
Last week of August.
Last week of August.
Before Labor Day.
Right. Well, nobody's gonna make you change, the hospital's not gonna make you change your travel dates. They just need to set up a date to interview you at some point.
Right.
So-
Even if he was at the top of the wait list.
Right,
They would still give like 3 or 4 different dates of availability.
right.
But at this stage, we don't even know where he's at. He could be like number 100.
Right, no, I know.
So,
I have no problem with doing that, okay? I just wanna let you know.
No, I know, hon. You're not creating a problem. It's what, the problem I have is we gotta fix our next review date. You're leaving the end of August, right?
Last week of August.
So can we pick a review date like August 10th, maybe?
How about 24th of August?
Is that when,
I won't be here during August. I won't be back till Labor Day, I was saying.
well, you won't be back till Labor Day. So-
I'll be back right before Labor Day, like the last week of August.
So,
Get in
do
school.
you wanna have a
in
review
school.
date like July 27th, Mr. Paganelli? See how we're doing?
I'm saying August
Yes.
24th. I won't be here. Somebody sent me, I borrowed somebody's phone.
Okay, yes.
I already made arrangements for
We're
the,
gonna do a review July 27th at 9:30 to see if the hospital's been able to contact with you for an interview, okay?
you're gonna do a review July
27th.
27th.
You're
To
still
see
gonna be
if the
here?
hospital's been able to contact me.
Yes.
And if I'm not in state of Washington,
Well, I thought you were gonna be gone in August. We're talking about July 27th. You can be here July 27th, aren't you?
no. I just
Well,
said,
when are you-
I'm leaving for 2 months.
Okay, when are you leaving was my earlier question.
As soon as I get the ticket that my friend's sending me,
No, well, what does that mean? Like July
That means
10th,
like,
July
it'll
15th?
be here by airmail, I guess the next flight to Pennsylvania, Philadelphia. Until the end of August.
Okay, we're gonna need a review date to see how the hospital's doing. You wanna try 1, 2 weeks from now?
Yes, Your Honor, let's try the 29th. Hopefully we'll have a finalized date at that point, but for Mr. Bryan's unavailability.
Right,
And I will contact the hospital in the meantime. 2 weeks, I don't expect. we'll have
no, I wouldn't
date,
expect
but
an
I can
interview, but if
get
somebody.
some, I can get
if
some
somebody can
information,
tell us
even if
something.
there is no news.
All right,
I
one
have
more
one more
review.
thing, I have
one
one more
more-
thing, other thing to say.
What?
I have $3,000 income a month, okay? But it's going to my son in Seattle
Right.
to pay his rent and his bills,
Right,
okay? That
right.
doesn't touch me. I don't have any money, so
You
I'm still
still
looking
have-
for an attorney, but I
You
can't use that money.
Still have income which people who are entitled to public representation.
I don't have any way
Okay,
it's already
We're not gonna
going to
keep-
my son into
We're
his.
not gonna keep arguing this. You're gonna have to hire your own lawyer and you're also gonna have to cooperate with the hospital. So, we're coming back on the 29th of June at 9:30 to see what Mr. Paganelli can tell us about whether or not the hospital is going to contact you or is trying to contact you, okay?
Yeah, but I might not, but I won't be here though.
Well, you or your wife can
Oh, she'll get
call.
the message.
Right,
And I'll call, and
Somebody
I'll
can
contact
call.
her from Pennsylvania.
Yes.
Yeah, I'll call once in a while.
You can always call
my
from Pennsylvania, okay?
Yeah.
All right, June 29th at 9:30, all righty?
June 29th
Yeah,
at 9:30,
yes, sir.
June.
June 29th,
You're
that's
gonna
correct.
find out whether or not
We're gonna find out
the
what
hospital's contacted. In the meantime, I'll be still getting an attorney for.
I think that would be very good for you to get a lawyer, yes. That's my
Okay,
honest
so
opinion.
you might not see me till like, with, Labor Day.
As long as we know where you are, okay?
Okay.
All right, Mr. Bryan,
We understand each other?
I think we do. We'll see you June 29th at 9:30, either in person or on the phone. All right, you can call.
Oh, cell phone.
Well, find someone who
I travel
does.
without a cell phone.
I'm
So
sure
when I
there's
get to
some.
Pennsylvania, I'll make sure that I keep contact with my wife and see what she
Yes,
says.
that would be a good
right?
idea.
She has more sense than I got.
I believe that. See you later. Oh, now we gotta get
Your
back.
Honor, Zoom works without a cell
Zoom is
phone.
wonderful,
You,
yeah.
you can call in the old fashioned way.
I know.
It's not as convenient, but it does work without a cell phone.
First case on the landlord-tenant docket is Equilibrium Management versus Faye Carmouche, file 26-42318-LT. Who do we have?
Good
present for that
afternoon.
matter?
Yeah, good afternoon, Your Honor. Nicholas Garlinghouse on behalf of plaintiff, filling in for Mr. Whitty today.
Thank you. We have Ms. Carmouche or Michael Workman present. Counsel, what do you want? You want to tell me what's going on with this file?
Yes, Your Honor. This is a kind of an unusual circumstance. It's a termination of tenancy due to damage and health hazard due to violent threats and the defendant apparently attempting to hire someone to kill the landlord. This is also well, there's also another case for non-payment of rent that's apparently set for a trial on the 29th. So with this case, because we don't have a second mailing and I'm not showing personal service, I'd request just a hearing date for this one as well. Possibly, if we could do the same time as the other, that might make the most sense.
I don't see how you can get what you're asking for. The only thing that I see on the documentation is that an attempt, I mean, it's bad enough, but attempt to hire someone to kill the property owner. That's not a health hazard to the property. It certainly is to the defendant or to the plaintiff. I get that. But
Yes.
I don't see how I can handle that through a landlord-tenant matter. That's a police matter. That's a PPO matter. But I don't see how it has anything to do with a health hazard involving the building. It's not a feces throughout the building. It's not a dump of oil all over the building. It's not a chemical spill. It's not rats and stuff running all over the place. Tell me how am I supposed to do something on a landlord-tenant matter where there's a threat to kill somebody?
Well, Your Honor, I would say ongoing violent threats would be something that would be a hazard to someone's health, at least.
True, but it's got nothing to do with the building. The building's not in jeopardy. I can't give you the building because she makes threats to the owner of the building. That's not a landlord-tenant issue. She may need to go to jail. She may need to go to the hospital. I don't know, but I can't give you the building because she makes threats.
If I may speak, Your Honor, under the health hazard code, and we submitted additional documents, we have a approved PPO and there's an ongoing investigation. But under the code, it allows the landlords to file an immediate petition for removal of the property. This affects the landlord's ability to maintain and operate the premise in a safe and useful manner. We can't be on property, and I can't operate it if I have a tenant openly trying to hire people to kill me. So we submitted the PPO, that has been approved. She has been served. It is in effect. She is in the community. And we are allowed to file. This is our way to file for protection against us and our employees, specifically me.
I'm unaware of this provision that you're talking about. So if you want to submit it to me, I'll review it. But my experience in the past and my reading of the statute in the past doesn't allow what you're asking me to do. Personal protection order protects you, the police report and the investigation protects you, but I don't see how giving you the building without any ability for her to address her other issues, which are coming up on June the 29th already anyway. I don't see it that I have the ability to do that. So if you want to submit whatever documentation that you're referring to, I'd be happy to review it. And if it's as you say it is, then I'll be happy to do what you're asking me to do. I just don't have that thought process in my mind right at the moment. So with that, I'll wait your documentation.
Okay, thank you, Your Honor. We'll get that submitted right away.
Thank you.
All right, and this is file 25-7088FH. Ms. Abbott is appearing by Zoom video. Looks like she's joining the meeting. This was a case that was scheduled for sentencing last week, and we had I had indicated an intended sentence that did not comply with the terms of a sentence agreement. Therefore, Ms. Abbott withdrew her plea, which was her right. And then I was presented with a stipulation to remand the matter to the district court for misdemeanor plea taking. Spoke with counsel in chambers and advised them that I would not be remanding to the district court, although this court does have the authority to do so under People v. Kramer. Under 6.008, the court also does retain jurisdiction over misdemeanors for plea and sentencing in this court. And I've done both. It's sort of on a case-by-case basis. In this case, where I have announced an intended sentence, it'd be my intention to not remand to another court, because doing so could encourage not only this defendant, but any future defendants. That type of remand, the timing of that remand could encourage forum shopping or judge shopping. I just don't want to encourage that. So the case will remain with this court. And so, Mr. Krissy, the status given that is that you desire another docket call, is that correct?
I would, Your Honor, and ask for another docket call at this time.
Any objection, Ms. Goodrich?
No objection.
Okay, so we'll set this for docket call. July 7 at 1:40. Would that work, Mr. Krissy?
You said 1:40, Your Honor?
Yes.
Yeah, that should work for me.
Okay, so we'll continue this docket call to July 7th at 1:40 in the afternoon. And I'll allow Zoom appearances for that hearing if that's what works best for Ms. Abbott. All right, anything further on that file from the defense?
Not this time, Your Honor.
From the people?
No, Your Honor.
Okay, Ms. Abbott, you're all set today.
Thank you, Your Honor.
All right, Ms. Heap, we'll see you that next date. Is that Angie showed up?
Sorry,
And Your
Judge.
Honor, this was continued from the more, well, there was some confusion about the state or city case, but I'm gonna hand up my notice of appearance. Also handing up a 1077 eval. This one specifically orders that the eval be done at the hospital,
Oh,
because we were here about a month ago, and what happened was she was found incompetent.
yeah.
What hospital, sir?
Hang on.
Western State.
Why do I have to go to Western State again? You're not giving me my
No, no, no,
medication
you're not.
here.
Can we mute her?
Yeah, we're gonna have to mute her.
Okay. As court can see that there's some concern.
Yes.
There was an evaluation done. She was found not competent. But in that same report, it said, gee, we only have 29 days to deal with. We can't restore her.
Right.
So the case was dismissed. And in fact, we had the DCR eval stating she was gravely disabled.
I recall that.
And we were hoping that an ITA process would occur. My understanding is that essentially the hospital just released her, and that there wasn't a DCR eval done. There was no ITA done. There was a DCR that was done ahead of time. But so this kind of circumvents and prevents that. One of the boxes on the form specifically states the court finds that the evaluation outside the jail setting is necessary for the health, safety, and welfare of the defendant.
Yeah.
And I think that directly applies here because she'll be at Western State, they'll be able to do the evaluation, and even if it's only 29 days, in the past, she wasn't able to get fully restored, but she was able to get greatly stabilized.
I think we have a communication from the jail.
She returned to herself voluntarily. Okay.
Right, thank you.
Yes, sir. Given the circumstances, we can still proceed. So I'm asking the court to sign the order that the eval be done at Western State.
Right.
It's anticipated she'll be deemed incompetent. It's anticipated there'll be requests to have her restored for those, even if it's only 29 days.
Right.
The theory being is at the 29-day mark, if she's still not competent,
Right.
instead of just being dismissed, she'll be in a clinical environment where they can initiate the ITA process down in Pierce
And
County.
you think we are able to facilitate that maybe?
Yes. The order, this is a standard order. One of the check boxes is for inpatient evaluation. And one of the check boxes specifically states that the court finds that the evaluation outside the jail setting is necessary for the health, safety, and welfare of the defendant. And given that she's gravely disabled, given that we were just here a month ago and she was just released by OMC.
And she actually has decompensated a bit.
Yeah, I think this is the only alternative. And the order also allows transport, be it Forks PD. Initially, I thought it was a state case, so I included the county sheriff, but any agency can transport, or presumably it's going to be Forks. But
PBH, did you hear all that? Angie was having she was fussing in the jail and slamming things around. I don't know how much of that you heard.
Yes, Your Honor, I heard all of it.
All right.
And I had a chance to briefly discuss this with Ms. Weaver on Friday, if I recall. But in the future, there might be some additional orders to help prevent this. But for now, for this particular case, I think sending Ms. Jones to Western State for the eval is the best course.
I do too. I don't think I've ever seen her quite.
And then, yeah, if we can come back on the 15th just to see if she's been transported or what the status is, that would probably be
All right, Mr. Black, we'll have a review on the 15th, see how she's doing.
Ms. Breslow has the board case.